Chairman Olson, we're live.
Thank you, Carol, and welcome to another day of House Judiciary. Today, we will be looking at Senate Files 25 and 26, and if time, we will be looking at Senate File 13. Carol, will you please call the roll?
Representative Crago.
Here.
Representative Larson.
Here.
Representative Oakley.
Here.
Representative Provenza.
Here.
Representative Rodriguez Williams.
Here.
Vice Chair Washit.
Here.
Representative Yen.
Excused.
Representative Zwanitzer.
Here.
Chairman Olson.
Here.
8 present, 1 excused.
Excellent. All right. We will take up collectively Senate File 25, District Judge Positions Authorization, and Senate File 26, District Judge Positions Authorization and Funding. And we'll just pick up where we left off, but Ms. Butler, I guess we'll start again with you.
Good morning, Mr. Chairman, members of the committee. My name is Elisa Butler. I am the State Court Administrator at the Wyoming Supreme Court. So Chairman, with your permission, I'd like to just give you a little bit of background on these two bills, maybe give more of some context as to why we're at where we're at today. So Senate File 25 was the first bill that the Joint Judiciary Committee passed out of committee, and I believe that was in the September meeting. As part of that bill, it was an authorization for 3 new district court judges in the 3rd Judicial District, the 6th Judicial District, and the 7th Judicial District. Historically, what the legislature has done is they have required a certification process to ensure that there are sufficient quarters for those judges before they will appropriate money. And so that first bill, Senate File 25, required that certification process, which means the Chief Justice has to certify that there is space available for that judge in a sufficient courtroom. And so Senate File 25 basically does that. It requires a certification process for all 3 district court judges in all 3 of those judicial districts. After that September meeting, we learned that there were 2 of those spaces. So in the 3rd Judicial District and the 7th Judicial District, that there is currently space available now for those judges. There are courtrooms and there are chambers space. So they have offices for staff. And so what this committee did in its next interim meeting is it passed Senate File 26. And what Senate File 26 does is it appropriates money for a judge in the 3rd Judicial District, which would be housed in Evanston, and in the 7th Judicial District, which would be housed in Casper. And then it does the certification. So it authorizes a new judge in the 6th Judicial District, but it requires the certification process because they are still working on building out a space for that 4th judge up in Gillette, Crook, Newcastle. So that's just a quick and dirty explanation of the 2 bills before you. We are obviously very much in support of these 2 bills, would urge the committee to pass this out of committee, and then I would imagine it will go to appropriations next to talk about that appropriation. So I'm happy to answer any questions. I think there was just to some of the questions I got during the last on Friday was, whether or not we even need Senate File 25. In truth, we don't. If Senate File 26 passes, Senate File 25 is no longer necessary. So, Mr. Chairman, with that, I'd be happy to answer any questions. And I do believe we may have a judge or 2 waiting in the wings if you all have questions for them.
Representative Oakley.
Thank you, Mr. Chair. Good morning, Ms. Butler. When this was going through, Appropriations has discussed this. Is that correct? And have they discussed this that you're aware of?
Ms. Butler.
Mr. Chairman, Representative Oakley, they have not. It has gone through the Senate Appropriations side, but not yet through the House Appropriations Committee.
Was there any discussion as far as
Representative Oakley.
Sorry, Mr. Chair. Mr. Chair, Ms. Butler, has there been any discussion that you're aware of that surrounding funding that's more than just the space for chambers. If there's a more full discussion about funding.
Ms. Butler.
Mr. Chairman, Representative Oakley, the discussion we had with the Senate appropriations was centered around the appropriation itself, which is, if you look at that fiscal note, it is for each of the courts, it would be $1.1 million a biennium. And so what that covers is it covers the staff. So the district court, each district court judge, obviously the salary of the district court judge, and then each district court judge has a judicial assistant, a law clerk, and a court reporter. So that would cover those staff expenses. And there are a few other expenses in there, but generally the bulk of that is to cover the staffing costs for those chambers.
Ms. Butler, when you said Senate appropriations discussed it, did you mean collectively the two bills, or did they only see Senate File 26?
Mr. Chairman, to clarify, they only worked on Senate File 26.
And so into Senate File 26, it authorizes and funds the 3rd and the 7th, which are essentially certified. And we would still need to come back in a subsequent year to officially authorize the 6th. Is that how that works?
Mr. Chairman, that's correct. So in a subsequent year, we would need to come back and ask you for an appropriation in order to fund that new judge in the 6th Judicial District. That is actually the process they went through here in Laramie County. There was a judge authorized prior to the time that it received an appropriation.
Okay, so actually, I guess so my words are correct. Senate File 26 authorizes the 6th Judicial District position. It just does not fund it yet.
Mr. Chairman, that's correct.
And then it would still require the certification process.
Mr. Chairman, that would be correct. In order for us to receive an appropriation, the Chief Justice would need to certify that there is space available for that judge in the 6th Judicial District before this body would give us any money. It's my understanding.
Okay. Committee, additional questions for Ms. Butler? Vice Chairman Washut.
Thank you, Mr. Chairman. Ms. Butler, do you know if any of the judges who are with us today are from that district that won't be funded currently?
Ms. Butler?
Mr. Chairman, Representative Washut, I am not sure. I believe that Judge Blumel is on the line and he is from the 3rd Judicial District, but I don't know if there's anybody on the line from the 6th.
We have Judge Wilking too, but that's the 7th.
Yep, Judge Wilking is the 7th, Mr. Chairman.
Please.
That said, do you have any sense of the time for when that building is going to be complete in the 6th?
Mr. Chairman, Representative Washut, it's my understanding that the county commissioners in Campbell County are very supportive of getting a new judge up there. And so they are currently working on, they have purchased, I believe, a building across the street, and they're kind of doing some shifting and remodeling in order to house that new judge up there in the 6th.
Any additional questions for Ms. Butler? All right.
Thank you.
Thank you, Ms. Butler. Carol, will you please let Judge Blumel and Judge Wilking in?
They're both appealable.
Sorry, let Judge Johnson in as well. Welcome, Judge Blumel. Welcome, Judge Wilking. We're letting Judge Johnson in. Maybe.
Judge Johnson should be there as well.
Judge Johnson, you can light up your camera if you'd like. It's possible she just stepped away. Go ahead, Judge Blumel, Judge Wilking.
Mr. Chairman, I'm Judge Joe Blumel in Kemmer. I handle both Uinta and Lincoln County, and I'm in the 3rd Judicial District. And Mr. Chairman and members of the committee, I am supportive of this bill 26. It's you and your committee have heard the testimony presented during the interim. I am here to answer any questions you may have, and I think Ms. Butler very succinctly and appropriately described everything that I have, but I'll answer any questions you may have. Thank you, Mr. Chairman.
Committee, do you have any specific questions for the 3rd Judicial District? Representative Oakley?
Thank you, Mr. Chair. Good morning, Judge. I was just wondering if you had any comment since even last we met about any growth that you may expect in your district.
Judge Blumel?
Thank you, Mr. Chairman. Representative Oakley, I think that all of us in the state are excited. I don't know that anybody is as excited as the folks in Lincoln County and the Kemmer area of the incoming Terra Power nuclear power plant. They have already begun doing core samples for the permit. They've had meetings. Housing has already started evolving. This morning, I met a surveyor who was indicated that he is moving to Maine because he doesn't want to contend with prices of nuclear power construction. And I understand that we are already having plans that dirt will be moved and the dirt work will be done this summer. So we obviously have that. I also understand, and I've not got the details. I've just heard it secondhand, but I believe that Representative Stith has some insight that there's some additional items happening in Sweetwater County for the trona mines. We have the carbon capture reinjection program with Exxon Chute Creek that had been put on hold with COVID that I believe is coming online. And then we also have some additional work happening at the Opal Hub. So frankly, Southwest Wyoming is going to experience what I think we have truly talked about in the past and we all know as a boom. And I failed to actually add that we have a solar farm where the Industrial Siting Commission has recently had hearings south of Cokeville. So it's not just the Kemmer area. We're having significant economic upswings anticipated here in southwestern Wyoming. Thank you, Mr. Chairman, Madam Oakley.
Any follow-up, Representative Oakley? Committee, any other questions for the 3rd Judicial District? All right, well, welcome our 7th Judicial District judges.
Good morning, Chairman and members of the committee. My name is Catherine Wilking, and I serve along with Judge Johnson and Judge Forgy in the 7th Judicial District, and I'm very respectful of your time. I just signed on in case there were any questions particular to our jurisdiction. So I'm happy to answer those if I can, but I don't want to belabor the point. I think all of you, especially those in my jurisdiction, have heard from me quite a bit. So for that, I'll answer any questions that you might have. Thank you.
Committee? All right. Judge Johnson, did you want to introduce yourself and give us any comments on these bills?
Good morning, Mr. Chairman, members of the committee. My name is Carrie Johnson, and I'm a district judge with Judge Wilking and Judge Forgy here in the 7th. And like Judge Wilking, I will not belabor the point and take up any more of your time. So I would also answer any questions that you might have.
Judge Johnson, when did you assume the bench?
I was appointed in December of 2018, and I took the bench in January of 2019. So just a little over 3 years ago.
Okay, excellent. Well, I guess I practice a little in Natrona County, but not enough to wind up in front of you. So I guess I thought you were even newer than that. But thank you for thank you for your continued and multi-year service on the bench.
Thank you.
Committee, anything? Yep, Vice Chairman Washut.
Thank you, Mr. Chairman. Just like to mention, I think this is the first time that Judge Johnson has testified before House Judiciary, and just want to invite you back in the future.
Mr. Chairman and Representative Washut, thank you very much. I'll come back as often as you'll let me.
We love our judges, all of our judges, and everything they have to say. All right, who gets the new office? Or is that undecided? The new judge. Depends on if it has a better window view or.
I don't know, Mr. Chairman, I don't know that anybody wants to move.
Yep. Yep, I get that. Okay. All right. Thank you, Judge Wilking, and thank you, Judge Johnson. All right, we do have, that's all of our online testimony, Carol. Okay. In the room, who would like to testify on these Senate files? Beth?
Morning, Mr. Chairman, members of the committee. Beth Lance, Wyoming Trial Lawyers Association. I won't belabor the point either. This has been looked at through the interim, but our members and our association is in support of both of these bills. Our members would agree with the data that the three areas that have been pinpointed where there is a need for an additional judge, our members see that and certainly would agree that an additional judge would really assist in access to justice for our clients and for Wyoming citizens. So we stand in support, and I would answer any questions.
Representative Zwanitzer?
Thanks, Mr. Chairman. Do we have any data on how long it takes to get a standard criminal trial in Wyoming versus other states? When we talk about access to justice and timelines, I don't know if there are national statistics that you know of, or maybe Ms. Butler does, but where we are and the average length of, yeah.
Ms. Lance?
Mr. Chairman, Representative Zwanitzer, I think Wyoming is in compliance with the Constitution, and our Constitution does require speedy trial anytime that a defendant requests it. And when a speedy trial is requested, a trial has to be held within 6 months. I don't believe any of our courts are actually in violation of the Constitution. What is happening is because of the priorities that have to be made for criminal trials and also under our statutory construction in Wyoming for juvenile cases, they have a very tight timeline, 60 to 90 days at the most, before those may be adjudicated. And so I think what becomes the issue is we're getting backlogged with our regular civil litigation because of the priorities that have to be made for our criminal and juvenile cases.
Thank you. Ms. Lance, do you have any, and it doesn't have to be specific data, it could be more anecdotal from your members speaking inside of these three districts, any I'm particularly interested in the 3rd Judicial District and access to the court in terms of being bogged down, et cetera. Do you have any information you could share from your, or any of the districts really?
Yeah, thank you, Mr. Chairman. Certainly, I myself practice occasionally in Natrona County, and we've been seeing extraordinarily set out dates for family law cases there. And of course, our Supreme Court has recently made an opinion where they're really encouraging district court judges to get these family law cases handled much more quickly because it is really detrimental to children and families to let those languish. But unfortunately, as I said, I think with just the prioritization that has to occur for criminal and juvenile, often we're looking at 8 months, 10 months, a year for those family law trials to be held. And that really becomes much too long.
Ms. Lance, do your members ever discuss the problem you just highlighted as a whole? I mean, is the long-term fix more judges in every district at some point, or are there other ideas floating around on how we could address those family law dockets, the criminal dockets, whether that means full-time magistrates or commissioners that can hear those contested cases. Like, for example, in the federal court, we have a magistrate who hears all of our discovery disputes in order to keep the docket from getting backlogged. Do your members ever discuss something like that, maybe in the judicial districts?
Mr. Chairman, certainly our members would be open to any of those kind of creative solutions that would assist in moving family law cases. Certainly, I know that here in Laramie County, which is where I primarily practice, the judges spend a lot of time really encouraging mediations, encouraging guardian ad litems to assist. They feel that those things both often help settle cases so that hopefully a trial is not required. So I know our judges are doing what they can to try to move these cases off the docket altogether. But certainly if they had help with additional magistrates or judges, I think that certainly would be the most important way to assist.
Okay, thanks. I ask those questions because I think they're going to be relevant questions we get on the floor when we take these bills to the floor. Is this the long-term solution that as we do our because one of the other things we're budgeting for right now is to do a case weight study for the courts and continue looking at this. And so I think that's going to be a long-term substantive question for the legislature to answer is once we have that data back, and let's assume it tells us that we still need more judges, which I assume it will tell us that. And so when it does, is that, just trying to get you and your members, I guess, thinking as we move into another interim, we're probably going to be spending more time trying to figure that out, whether this is the system that we want to keep and we continue to add judges based on those studies, or whether we start to look at other alternatives. So appreciate your insight.
I appreciate that, Mr. Chair.
Thanks, Ms. Lance.
Thank you.
Anyone else wishing to testify on these bills? No? All right. There's nobody else in the virtual world, Carol. Just want to double check. Don't want to cut off testimony. All right. We'll close public comment on Senate files 25 and 26. Committee, what is your pleasure? Representatives Wanitzer?
Sure, Mr. Chairman, I would move Senate File 25 do pass.
Okay. Move Senate File 25 do pass, seconded by Representative Craigo. Committee, so you know what we're looking at. I think it would be prudent to pass both of these bills out of our committee. We know, as the discussion I had with Ms. Butler, is what will likely occur with Senate File 26 because it has a direct appropriation. It will be directly referred to appropriations, where we will have to address the bill and the appropriations there. Senate File 25 won't be referred, but it will be able to sit inside of the general file while we bring 26 through the process. So I think it's necessary to have both bills, in my opinion, out on the floor. And then just so you're kind of seeing what the process might look like, especially for newer members, I think at the end of the day, if one of them passes through, the other one can just sit on general file. So we don't need both bills. That's true, but having them both out there, I think is going to be helpful. Any discussion on Senate File 25 or amendments on Senate File 25? Vice Chairman Washut.
Thank you, Mr. Chairman. Just so we're clear, if we authorize this judge that doesn't have office space in the 6th Judicial District, there's still going to be more legislation required for the appropriation at a later date. So just having the authorization done doesn't really move along the timeline. But I agree with you, having 25 on the floor is a prudent approach.
Further discussion, committee? All right. Carol, will you please do a roll call vote on Senate File 25 District Judge Positions Authorization?
Representative Craigo,
Aye.
Representative Larson,
Aye.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Rodriguez Williams,
Aye.
Vice Chair Washit,
Aye.
Representative Yen,
Aye.
Representative Zwanitzer,
Aye.
Chairman Olson,
Aye.
9 ayes.
Committee, what is your pleasure on Senate File 26? Moved by Representative Oakley and seconded by Representative Craigo. Yes, discussion on Senate File 26, Representative Oakley.
Thank you, Mr. Chair. I guess I wanted to make this comment with the last discussion that we had. I would have, I guess, possibly asked to have Judge Blumel say this, but it came from him and I hearsay is allowed. So I'm going to, through some discussions with him on, because it is civil trials that end up getting backed up, that the third judicial, I think this is right. It was something like the third judicial is currently at 2.5 years waiting time for a civil trial. And they're hoping with this to get it to a year or under. So just since that discussion came up.
Yeah, and Representative Oakley, I think that's going to be an important data point that we'll want to share with the floor. Absolutely. Appreciate that. Committee, other discussion on Senate File 26? All right. Carol, will you please do a roll call vote on Senate File 26, District Judge Position Authorization and Funding?
Representative Craigo,
Aye.
Representative Larson,
Aye.
Representative Oakley,
Aye.
Representative Provenza.
Aye.
Representative Rodriguez Williams,
Aye.
Vice Chair Washit,
Aye.
Representative Yen,
Aye.
Representative Zwanitzer,
Aye.
Chairman Olson,
Aye.
9 ayes.
Now I expect to have 9 members fully ready at the mic defending these bills. Good job, committee.
Are you floor managing them, by the way?
Yeah, I will likely floor manage these. And if there are there's particular things I'll ask for your assistance in. So we'll get to that as we get closer, but I'll floor manage. Carol, we will now move to Senate File 13. Committee, you have a little blue bill, means it's been amended and now it is engrossed in front of us. This is a bill from Joint Transportation, and I don't have a Joint Transportation member here to present the bill to me. Oh. So let's see. When does transportation meet? Okay, so they're not meeting right now. All right. Yeah, but it's not your bill. It's the Joint Transportation's bill, and they should be here to present it. So let's pause for just a minute and let's see if we can find, let's see, we would like Chairman Burkhart or Vice Chairman McGuire. Might be good.
Or anybody from the Senate?
Or
side?
anybody from the Senate side. All right, let's pause and see if we can find a senator who or a representative who wants this bill. Representative Brown, welcome to the table. Please have a seat. Do you need a copy of the bill? Well, we'll start with, it's Monday and it's 8:33 and you're in the House Judiciary Committee.
And you probably could have the agency.
Well, Mr. Chairman, good morning.
Welcome, Vice Chairman Brown.
So it sounds like you guys are interested in a bill that we've got in front of you guys. Good news is I've got plenty of backup behind me. So as that will probably come into far more play than I expected and probably than you expected this morning. What you've got in front of you is a temporary delegation of parental authority. What this particular bill does is this provides the additional leverage for service members when they are deployed to have the delegation of authority over the children. And to be honest with you, Mr. Chairman, I haven't seen this bill in quite a few months. So I have a hard time remembering exactly what this is, but the good news is I just had the retired colonel tell me that he will walk you through the bill. But as far as the actual process of the bill, this is for temporary privileges. This is not anything that is going to be set, forth in stone that would keep the parental authority in place throughout a lasting more than temporary. So if a member is TDY and or deployed, that's where this would come in. So, Mr. Chairman, I do apologize that I don't have much more for you this morning. I was literally just walking in, was unprepared for this. So I will stand for any questions if needed, though.
Representative Brown, do you recall the genesis of this legislation? Why did it become an interim topic? Where did it come from?
Mr. Chairman, I would lean a little bit deeper on the bench for that one. I do remember that there was some circumstances in which the guard members in specific had issues getting certain levels of authority, getting power of attorney over for their children. But I would rely a little bit deeper on the bench for that.
Oh, well, this might be, here's your bench is building. Welcome, welcome, Chairman Burkhart.
Thank you, Mr. Chairman. I apologize. I thought this was handled, but I appreciate your patience and the patience of the committee.
Thank you, Chairman Burkhart. We're looking at Senate File 13, temporary delegation of parental authority. My question to Representative Brown was just, do you recall the genesis of this bill? Why was it an interim topic? Where did it come from?
Mr. Chairman, the bill came through the military department to address some issues that they've had with delegating parental authority when people are on active duty, where both parties may be on active duty in different locations, and how to address those issues and control it, where one party may have custody and may want to do something mischievous while the other party's away. And that was the genesis of it and the main reason.
Chairman Burkhart, did you hear testimony from parents?
My recollection is we did not.
Did you hear, did you hear testimony from guard members?
Mr. Chairman, no, all testimony that I recall came from the department.
Chairman Burkhart, are you familiar with the amendment in the Senate?
Mr. Chairman, no.
And you don't have to be. I was just going to ask if you had a chance to review it and you thought it was favorable to the bill or had any concerns about it.
Mr. Chairman, I did not. As I said, I thought this was handled. And Mr. Chairman, not having a copy of the original bill, I cannot tell you what the changes were.
The change, I could give you a copy, Chairman Burkhart. The change is on page, oh, Carol's got you. The change is
Oh,
on
thank you,
page
Joe.
2, and it adds, I believe, a notice requirement under, it is what is now subsection C, more fleshed out. And it looks to me like it is a delegating parent or guardian shall provide notice to any non-delegating parent before executing a power of attorney. I think that's the gist of the changes and notice requirement, but I would ask you thoughts on the notice requirement, but if during the interim you didn't hear from any parents, I guess it would be hard to know a parental thought on that.
Mr. Chairman, I agree with you. It would be hard to know what parents were thinking, but I think the idea here, looking at the amendment quickly, would be that, again, where there's a custody issue, the parents have to communicate. And I think that was the main genesis of the bill, was to keep one parent or one guardian from doing something where the other one didn't know what was going on. Remove the child from the state and claim total custodianship of the child in another state, that sort of thing. And I think it was to prevent those sorts of things. And I think the department is here and can address some of those issues also.
Certainly. Committee, any other questions for Chairman Burkhart or Representative Brown?
How's your Monday going?
It's a good way to start a Monday, huh? Thank you, Chairman Burkhart. Thank you, Representative Brown.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman.
All right, let's bring the department up. Welcome.
Hey, good morning, Mr. Chairman, members of the committee. For the record, my name is Major General Greg Porter, and I serve as the Adjutant General for the state of Wyoming. To my immediate right is our senior counsel, Chris Smith, and further to his right is our 153rd Airlift Wing Senior Counsel, Major Karen Hinkle. This is the first time that I can remember testifying in front of House Judiciary, sir. So as some of you I have not met. So appreciate the opportunity this morning, sir. So let me go a little bit deeper in the history if it pleases the chair and the rest of the committee. This actually started as a personal bill last session. And actually the military department testified against it because at the time it had a restriction that these delegations of parental authority were only for 6 months. And so we had a concern for those that are deployed on the Army side. At the start of the war, we were deploying for about 18 months in length. By the end of the war, we were deploying for about a year. The air tends to deploy for about 6 months in length. And so we were concerned that if we had restricted the limitation on parental delegation to just 6 months, that we would have members deployed and not be able to renew these sort of delegations. So in the spirit of no good deed left goes unpunished, that we were asked, since we had testified against it, if we would assist as a military department in crafting a bill that would not be damaging to our personnel. And so as you heard from the chairman, it wound up back in the Military Affairs Transportation Committee to sort of work that. And that's sort of how we got to this point. I will tell you from the military department standpoint, there is nothing in this bill that we need to have in order for our soldiers and airmen to deploy. The only thing we are concerned about is anything in this bill doesn't restrict us, like a 6 month or something along those lines. So we are able to execute powers of attorney and do this delegation if there was no bill in place. I just wanted to be clear about that. Our interest really got piqued when they started putting some restrictions in. So if it pleases you in the committee, I could have Major Hinkle sort of run through the bill to include the amendment and kind of talk through sort of the piece of that, the piece of legislation.
General, who was remind me who brought that personal bill? I'm having a hard time remembering this bill.
Yeah, Mr. Chairman, I believe it was Senator Kinski.
Okay. Now Now I think I have some recollection of it. Okay. Committee, do you have questions for the general? Yes, Representative Zwanitzer and then Representative Ian.
Thanks, Mr. Chairman, General, or whoever. Any discussion with Department of Family Services, right? So we have a whole lot of laws in place on our other entities when, even when I have a foster kid, I can't leave them with another parent who's not certified for more than 48 hours. And there's a whole lot of federal guidelines and restrictions about who can take care of children who aren't their biological parents. And just along the way, anywhere in the interim, was DFS brought in to discuss any of this?
General?
Mr. Chairman, Representative Zwanitzer, I don't believe we talked specifically to DFS. You did?
Mr. Chairman, Representative Zwanitzer, my name is Major Karen Hinkle. I'm the staff judge advocate for the 153rd Airlift Wing. That means I'm also a member of the Guard. When we brought this to the Joint Transportation Committee last summer, we did actually have, if I recall correctly, DFS was on the line and had an opportunity to provide input.
Representative Ian?
Mr. Chairman, thank you. Was there if this is not a bill that's necessary for the military to deploy, then I guess my question is this bill necessary for anybody to delegate, or is the only thing it does is put a restriction in place plus the exception for the military? Thank you, Mr. Chairman.
Mr. Chairman.
Counselor?
Representative Ian, Mr. Chairman, thank you. So it is not strictly necessary to have this kind of legislation passed. Common law allows us to, at least under Wyoming, prepare powers of attorney to address a lot of these needs. The concern came that, I think there may be not everybody's on the same page about what common law authorizes sometimes. And so the background to this story was there was a judge who had, I think, a friend or something who wanted to take grandparent or grandchildren out of state and was advised to get a power of attorney to allow them to do that. And the person for whom that individual turned to legal advice said they weren't authorized to do it under Wyoming law because there wasn't a statute that authorized it. So that's really the concern, right? Whether that's right or wrong, common law authorizes it. There's just some misunderstandings out there that could affect certain parents. The military requires powers of attorney for military couples who have children or single parents who are in the military. And we've prepared these for, as long as I've been around and as long as Mr. Smith has been practicing without any issue. The only concern we had is that if the legislature chooses to pass legislation to codify this, that it do so in a way that doesn't hamper our military members and our parents from having to do this on a more regular basis than might be necessary.
Did you have a follow-up, Representative Ian? I have a follow-up. So then how does this, Counselor, how does this bill square with 20-2-205 on the temporary orders?
Mr. Chairman, if you'll give me just a minute to reference that statute.
It's the temporary military duty definitions, modification of orders for visitation assignments. This is when a military member receives temporary orders.
Mr. Chairman, I'm Chris Smith, the Senior Counsel for the Wyoming Military Department. In answer to your question, this bill has no impact on that. Obviously, I spent 28 years in the military, 35 years as an attorney. I've probably done over 1,000 of these power as an attorney. We specifically, it says both in this bill as well as in common law, it has no impact on any court order. What we're trying to avoid is people going back to court to try to take care of their kids. Our concern in the military is we require our members to be ready essentially at a moment's notice to get on an airplane and go to war. So we have what's called a family care plan where everyone who doesn't have a parent who's going to stay home if they deploy, so that's everyone but single parents and people who are dual military, as Major Hinkle mentioned, they have to have a plan. If we call them today and say, tonight you're getting on a plane and going overseas, who's taking your kids tomorrow, right? So typically there are two powers of attorney, one for the emergency, often a neighbor, a friend, somebody local who can take the kids to school tomorrow. Then there's usually a longer term one, typically a family member, the non-custodial parent, or until the non-custodial parent can come get the kids. We're a very mobile society. People associated with the military are all over the world. We have folks whose non-custodial parent are overseas or in Alaska or in Okinawa. They can't just take the kids. So the whole purpose of these powers of attorney is simply who's taking the kid right now until something happens. The law in the past, this legislature has passed several laws that said temporary military duty, like a deployment, cannot be a basis to change a custody agreement. This Senate file down on pages 3 and 4 specifically says nothing in this changes the custodial arrangement or can be used as a basis to change the custodial arrangement. So I don't know if I got to your question, Mr. Chairman, but basically this Senate file does not impact a court's order specifically by its terms.
Representative Zwanitzer.
Thanks, Mr. Chairman. Colonel, whoever. Are these orders, are they just these care plans? Are they kind of perfunctory when someone joins long before, they might be called, or are they last minute sometimes? Is this something everybody goes through who has children or a loved one, and it is immediately taken care of years in advance or 6 months in advance of a call up in pretty much every case? Could you just walk me through how that works?
Counselor.
Mr. Chairman, Representative Zwanitzer. So it's when somebody has a child, that's when this type of plan would be activated. Our regulations require them to have it on file with an individual in the unit that's in charge of making sure that they have all of these kinds of documents taken care of. And so as long as that child remains underage, the parent is required to have it, as long as they fall within a certain category of people that don't have a family member that would be remaining at home. So if we have 2 military members who are married together that have children, they're required to have it, and they're required to have a current one on file all the time. And right now we tend to do them for about 2 years is the duration that we have them, to minimize the risk that they might get a short notice deployment, not be able to take care of it, and they can just roll out the door.
Please follow.
So every 2 years are kind of automatically reviewed for everyone, regardless. The onus is not on the service member to come to you and update it. It's on the non-commissioned officer or whatever to check in every 2 years and make sure the plan is always current. Just walk me through how the plan is always current and how we know it's always current.
Counselor.
Representative, Mr. Chairman, Representative Zwanitzer. So the way it works, the onus actually is on the member to make sure that their documents are up to date, but we do have, we call them inspections, where different folks come through and make sure our programs are in compliance. That is one actually that we just recently had an inspection done to make sure everybody's documents were up to date. Some weren't. We've had a flurry of people coming through getting them.
Somebody had a question earlier on this side of me, though. No? Okay, Representative Craigo.
Thank you, Mr. Chairman, and this could go to any of the 3 of you. The General, you were talking about that, essentially this particular bill, you don't need it. So I have 2 questions kind of based on that statement. One, does the bill help the Wyoming military? That'd be my first question.
Counselor.
Mr. Chairman, Representative Craigo, my apologies. I would say it neither helps nor harms. It's just kind of a clarification of the procedures in this state, if anything.
Representative Craigo.
Mr. Chairman, thank you. So you answered my second question, which was, does it hurt the military? So thank you for that.
I am still curious, and maybe it's just because the bill was somewhat, I guess, handed off to you, and then you just did a good deed of shepherding it forward and making a change to it. But I am still curious why there were no parents that testified on this bill. It seems to tell me 2 things, one of 2 things. One, there's absolutely no interest from parents in it. not at least interested enough to show up and testify about the need for it, or, I just think had this been a Judiciary Committee bill, I'm very confident. That's usually what I see when I see a visitation or custody issues. We have parents testifying in front of us to let us know why this, usually there's a situation. It's one particular parent or a group of parents who were aggrieved. And so they bring it forward to us. Why were there no parents on either end testifying on this?
Mr. Chairman, I would say you're correct. I mean, we certainly looked at it through the lens of the military department. We did this. And, team, you can kick me back in bounds, but I think that was really the entire reason. That was the lens we looked at it for. And our interest in it was not to establish anything that sort of impeded our ability to do that. So when we're talking temporary delegation from our lens, we've got a pretty good handle on it. So I'm not sure, team, I don't know if you'd say anything different. I'm not sure that I really ever saw a need to go to the depths that you described, sir.
Counselor?
Mr. Chairman, if I may add to that too, as a legal assistance attorney for the Wyoming Military Department, I work with pretty much every military member who's a parent on the air side that comes through and gets one of these. For us at least, and I can't speak for parents outside of the military community, this is just a requirement that we have to meet. And frankly, most of them find it comforting to have it kind of in their back pocket, that they know that someone will have the ability to take care of their children and make decisions in the event that there's an emergency. Really, our interest in it was focused on the duration, because whenever we look at a shorter period of time, that creates a lot of stress for my members who have to come back in all the time, make sure their documents are up to date on a more frequent basis. And then I think they worry too when they have schools or deployments or other military requirements that are going to take them from home for a longer period of time. That was really kind of our focus on it. They haven't necessarily come to provide that input, but that's been my experience in at least working with the guard parents.
Sorry, I elevated you to the status of counselor. I thought you told me you were. But you are. You said legal assistant.
Mr. Chairman, my apologies. I'm a legal assistance attorney. So I'm the senior counsel for the Air Wing, but I also, as part of my duties, provide legal assistance in terms of making sure that people are ready for.
Now I'm sorry I demoted you.
No apologies necessary, Mr. Chairman.
And Mr. Chairman, if I could just add, having been around the Guard since 2002, during the Army Guard's large deployment in the 2008-2009 area, many dozens, if not hundreds of people relied on these powers of attorney, because some of those units went out the door fairly quickly. And actually the Air Guard went out the door right after 9/11 with about 48 hours notice. I had many conversations with various schools in particular about these powers of attorney. So there are sometimes issues that crop up. They're in Laramie County, certainly in the northern part of Colorado, most of the schools, most of the doctors, well used to seeing these kind of military powers of attorney, given our large populace. Some of the outlying areas, I remember having a phone call with somebody from Boise, Idaho, who took the kids for somebody and was having trouble getting them registered for school, for example. Always were able to resolve it just over the phone, attorney to attorney sometimes. So one thing this bill would do is to codify so that we could point in statute to something that we rely on. I know Major Hinkle did the research. If you look at the 8 surrounding states, including North Dakota, that isn't really a border state, but 6 of them have a statute. 2 of them don't. We don't currently. So it isn't something that you have to do. In terms of testifying, certainly we could have brought in a number of parents, military parents, who have relied on these over the years, although I don't think we could find anybody who had ever had a problem with using them. That's all I had, Mr. Chairman.
Representative Grego.
Thank you, Mr. Chairman. And this is putting you on the spot, but do you remember when you were working the bill during interim, was there testimony from family law lawyers from around the state of Wyoming?
Mr. Chairman,
please.
Representative Craigo, Beth from the Wyoming Trial Lawyers Association did provide testimony on the Senate side. You know, we have attorneys. I used to practice in the family law area, although it's been over two decades. We have drill status guardsmen attorneys who work for us part-time. Many of them, 3 of them in particular, work in this area. And so we talked through the bill in the interim, but there was no testimony in the interim from individual family law attorneys.
Representative Craigo.
Thank you, Mr. Chairman. So what I'm really curious about is the effect this bill would have on the non-custodial parent and how their rights may or may not be affected by the language we're putting in this bill, because to me, it's very broad. So I'd love, I guess, the 2 lawyers' opinion on that.
And just to, further qualify that, that is literally to the heart of my question of why there aren't parents testifying. Maybe it's not a concern for non-custodial parents, but generally, if it were, and if there weren't local practicing attorneys testifying again on behalf of those non-custodial parents, I'm having a hard time seeing their point of view on this bill.
Mr. Chairman and Representative Craigo, to answer your question, the language in the bill, and I'll point you to page 3, lines 7 through 20, and kind of on past that. So when you look at that language, what it does is it very clearly specifies that this power of attorney cannot override the rights and decision-making authority of any non-custodial parent. And the word parent, I think, was left in there very specifically because under Wyoming law, and this is information from Ms. Lance, who testified previously, was that parent means that they have rights associated with the child. If they don't, if those have been stripped by court, they're no longer a parent. So what it does is, and especially when we look at 12, if parents share legal custody and only one delegates rights, the delegation can only affect the person who's delegating its rights, and it doesn't override them. So they can't delegate away authority or decision-making that is not theirs. If a custodial parent is present, that parent's decisions will always override the person who has been delegated authority by the other person. It also, in paragraph 22 or lines 22, is very clear that it won't affect any authority provided by court order. So it's not meant to subvert child custody arrangements or any court decisions. It's really just a mechanism to say, so if it's me, if I'm the parent and I'm delegating authority, I'm just giving away the little chunk that I have to this person on a temporary basis to take care of decisions because I'm not there to take care of it myself. And I think the bill does a pretty good job of restricting that. And in fact, the proposed language in this particular statute is a lot more comprehensive than what we have typically seen in the surrounding states. Surrounding states generally are very concise in how they have put this into statute.
So once again, having not heard from parents, then is it the military's opinion that that the custodial parent should be looking to someone who is not the non-custodial parent to delegate the authority to?
Mr. Chairman, in some cases, I think it's not practicable for them in an emergency short-term situation to reach out to that custodial parent. So the idea is that this would, again, be your very short-term, I'm going out the door in 48 hours. My other person lives in Maine, and it's going to take them a long time to be able to get here and get the child, or to get the child to them, or we need somebody to ferry the child between here and there. So it's really designed to address those in-between moments. It's not designed to say, I'm taking your child from you and your visitation from you. And I think that's always the concern, is that it's like a loophole around a child custody agreement. It's really just a protection to ensure that the child has somebody that's responsible who can take care of decisions in the event they need to.
So what would happen if a custodial parent, we're in that scenario, they did not execute a power of attorney and they just deployed, and then the non-custodial parent found out about it, showed up? They shared legal custody? Would they have the legal authority to carry out everything needed to carry out?
Mr. Chairman, you're asking, would the non-custodial parent have the authority to carry it out? Or just somebody in the interim taking care of the child?
No, it's not what I asked. If the custodial parent
Mhm.
were deployed and they did not execute a power of attorney, and the non-custodial parent from Maine decided, hey, I should probably show up and help out with my kid, and he or she did, would they have the legal authority they need to take the kid to appointments, pick them up from school, do everything needed?
Mr. Chairman, yes, their authority is never going to be taken away from them
Right. And
unless
so,
there's a court order that does it.
do we have something that tells us that 90% of the time that doesn't happen, or 10% of the time it doesn't happen? Do you understand what I'm asking? Because if that's the default, what I just described, then the bill doesn't seem necessary. Neither does a power of attorney, but maybe you have more information about how often the power of attorney is used for a non-custodial parent.
Mr. Chairman, I don't have any statistics that can give you any insight on how often this is used. I can say anecdotally, this does become an issue for parents who have a short notice requirement to go somewhere else. And really the intent is to allow them to give the child to a parent or a grandparent or a neighbor or a friend until that other custodial parent can arise. Or if there isn't another custodial parent, to give somebody the authority to make those decisions while that actual parent is away.
So it sounds like there's two scenarios then that are like that if we were to narrow the scope of this bill, so it weren't so broad. One of them is when there is no custodial parent whatsoever. That one seems relatively obvious. Number two, your other example appears to be when there's a wide geographic spread between the parents, that we could potentially narrow the scope of this bill and capture both of those scenarios. Would that be, are there other scenarios I'm missing?
Mr. Chairman, there are some really interesting situations. So just if I may take a moment, when the non-custodial parent is local, we don't even care about powers of attorney. They're living in the same place. When the non-custodial parent is somewhere else and the custodial parent is remarried, the new spouse, so to speak, has no authority over that child. So giving the new spouse, hopefully I'm not offending anyone with my terminology, a power of attorney to take care of that child until and unless the non-custodial parent shows up is an important factor. Personally, for the military, because of what we ask of our people in terms of being able to go at a moment's notice, I would hate to see the bill get too restricted to the point where some very bizarre fact pattern shows up. They have a power of attorney that doesn't fit a more restrictive bill, and we get into a legal tussle when we're just trying to get the person out the door to defend the nation. So I would recommend that the bill stay as broad as possible. One thing I will say in line with your questions, Mr. Chairman, is the paragraph C that the Senate added on page 2B on line 17, that amendment was worked with the Wyoming Trial Lawyers Association, and it basically is a notice requirement. It has two stages. One is if you're a non-military family, you give notice to the non-custodial parent, again, only if there is one, that you're issuing a power of attorney to somebody else so that they have an opportunity to discuss it, come get the kid, whatever the situation. Because we do these prophylactically, so to speak, we do these for the military member way ahead of time often. We wanted the notice requirement to go into effect once it's actually used. So if I give Major Hinkle a power of attorney to take care of my kid as a single parent, she gives notice to the non-custodial parent of the child when she takes the child so that they have an opportunity to come get them if they want. I will say in the Air National Guard, we have people currently living in 22 different states. We have people who currently live in Europe and in Okinawa. Their family situations are unique and different. And if they come here for duty and then we deploy them, if they come with their family, their kids, it just gets really complicated fast. And that's why we make them have powers of attorney, because what we don't want, we need them to go to serve our nation. We don't want them thinking as they're getting on the airplane, who the heck is taking care of my kids? That is not the right time. Now, if you have notice of a deployment, often people will come back in and say, hey, I did this power of attorney a year ago. It goes to my neighbor. They're currently out of town, so I need to do a new one for this new person, and they're not getting on the plane for the next day. We do a new power of attorney. That's why we have lots of lawyers doing lots of stuff in the military. So I don't know if that gets to the root of your question, Mr.
Yeah,
Chairman.
let's break down subsection C a little bit then, because you said a few things that I think are very helpful. So one, on the 30-day notice, you mentioned when a military personnel might know of their deployment. And, give me some parameters. Is it unreasonable to say that they would know more than a month in advance?
Mr. Chairman, so these cover things such as formal training, like we're going to send you to Texas to go to training for 6 months. In that case, they will almost always know well ahead of time. We have also routinely deployed units in an emergency situation. Literally, they get on the airplane within 12 to 24 hours. So again, we're trying to make this as easy for the military member as possible, so they're not thinking too hard about what to do with their kids.
Right,
So,
and I understand that, but appreciate that what we're trying to figure out here is there may, and obviously the Travelers Association, when you work this amendment, is trying to figure out the balance between the non-custodial parent and the military. So I appreciate that. What I'm looking for is to understand whether the balance has been met. If someone were deployed within a 12-hour notice, clearly subsection C just it's not going to apply with the 30-day notice requirement. What I'm trying to understand is if it's unreasonable to assume that a military personnel would know more than 30 days in advance, maybe 30 days. And let me just give you some context. I mean, I believe you were in the room as we discussed the need for 3 additional judges in the state of Wyoming. Well, the reason for that, in large part, are 2 dockets, criminal and family. The family law docket is the one we're discussing. The family law docket is so bogged down that if a 30-day notice were received and the parent, even if the parent objected and said, the non-custodial parent said, wait, I can do it. This subsection C doesn't prohibit the custodial parent from moving forward with executing the power of attorney. And then if they do, and then they're on the plane and they're gone, peace of mind, kind of, not really, because now the non-custodial parent has the opportunity to object and go to court and challenge that. And we all know, point of my discussion is there is absolutely zero scenario that they get in front, not in Laramie County, at least, in front of a judge within 30 days. So counsel, what I'm trying to understand is if there is a better way to strike that balance, whether it's 60 days, something. And, the second part of it would be, and I would love your insight, the objection portion of it. This language, it just provides a notice. It doesn't say unless the non-custodial parent objects. And I don't know that from my point of view, and you could speak behalf of the military, but I don't know that that would provide me peace of mind as a military personnel if all I had to do was send a text message that said, hey, executed a power of attorney, gave it to my mom, and then I jump on the plane and then they file a lawsuit or they file for an injunction on that. So help me walk through those couple of scenarios.
Mr. Chairman, I want to clarify, and I will do that, but I want to clarify what C actually says. So there are 2 provisions to it. And this is again, page 2, line 17 and on. The first provision applies to non-military parents, and it's that they have to provide notice prior to executing any power of attorney. And so I think for the non-military folks, that should address most of your concerns, because the idea would be that they would do it in advance, and then any issues we get worked out in advance of anybody having to use it. I can't promise that, but that's the intent. In the second sentence, starting on 19, the intent is to shift the notice requirement to the delegatee, who assumes the authority of the power of attorney. And then once they assume that authority, then they provide notice within that 30 days. And that timeline is somewhat flexible, but the intent behind that was to shift the burden from a military member who may be deploying overseas into a place where they don't have ready communication access to try to notify a custodial parent that they had done this. In no case would it prohibit. So if you have a non-custodial parent who finds out that a power of attorney had been executed because they got this notice from the delegatee, as the custodial parent, it's going to depend on what their child custody arrangement says in terms of who takes the children when somebody deploys, but nothing is going to prohibit them from coming in and getting their children in that case and essentially kind of usurping the authority that was temporarily delegated to the delegatee. So while I think there's always an opportunity for people to be litigious if they choose to do so, the reality is that this won't override that non-custodial parent's authority to have care and custody and control over their children.
I see. So you're saying, so then let's just assume a standard scenario, which is really easy to do in Wyoming. Custodial parent has the child. Most of the time, the non-custodial parent has visitation rights every other weekend, some holidays, rotating in summers. So so what you're suggesting is that even if the power of attorney were given away to, say, mom, grandma, then the non-custodial parent would still have their normal visitation. Nothing would change for them unless they wanted to. And that was the reference to my statute earlier, right? If they wanted to file a motion under 20-2-205 and seek a temporary custody order, they still could do that, and they could actually have temporary custody during the period of time of deployment.
Mr. Chairman, they could file that, and then I don't have the statute number off the top of my head, but I believe that Wyoming also has a statute that allows the military member to delegate their period of possession to a parent in those cases of deployment in particular. And I would have to look at that statute number. It's not one that's frequently referenced. It has come up with legal assistance clients of mine on occasion, but it's pretty rare.
And then I think we're also suggesting that the non-custodial parent probably doesn't need the power of attorney if they share legal custody. If they share legal custody, then even if they don't have the power of attorney and some other third party has it, if non-custodial parent needed to make a decision and was present to do that, could do that.
Mr. Chairman, that's correct. So really the power of attorney only allows grandma, who normally wouldn't have parental authority over the child, to make a decision. Grandma can't override mom or dad if mom and dad have not, assuming they still have parental rights. So as long as those rights haven't been limited by a court order, that parental authority delegation is just to a third party who normally would not have parental rights over the child to assist in those interim gaps.
And then on page 3, lines basically 18 through 20, we're limiting the authority of that power of attorney by specifically calling out major legal issues such as changing schools, religious training, or non-routine medical care that we don't want the power of attorney to disrupt.
Mr. Chairman, that's correct. And then I would also just point out again, in line 19 and 20, it's very clear that if a parent is present to make decisions, that delegatee cannot interfere or override those. So that, I think, further strengthens any, well, I guess addresses any concerns that you were having in the scenario you just mentioned.
That language is a little, I guess it's a little clunky to me. If a parent is present to make decisions for the child, a delegatee may not interfere. Was there any thought given to flipping that into just simply saying which decision would control? If a parent is present to make decisions for the child, that parent's decision-making authority shall control, or what? The interfere is I'm not really sure what that means. Does that mean that they can't even talk? Does it mean that, what does it mean really?
Go
Well,
ahead.
I was going to say, Mr. Chairman, we did not draft that particular language. And
Okay.
so I think if there is better language that the committee would like, that's certainly something the military department is open to.
That I think would be maybe just a little stronger to drive that, your point home in referencing that this is really the section where you're trying to make it very clear that if they are present and willing to help, we don't want anyone stepping on their toes. Everyone appreciates that. Okay.
Yes, Mr. Chairman. In fact, if it said, if a parent is present to make decisions for the child, the parent's decisions control. You could say that if you wanted to. And I was just going to add, Mr. Chairman, in my experience, we often make sure our military members, the custodial parents, understand that if the non-custodial parent shows up at mom's house and wants the kid, they get the kid. I don't care what the custody arrangement is, as long as their parental rights have not been extinguished. Or some kind of supervised visitation only kind of thing. Because again, parents are the number one priority. If the parent shows up and takes the kid, we're happy. That's great. We're just worried about what happens when the parent's not available.
Representative Craigo.
Mr. Chairman, thank you. So following up on that comment, which is actually where I was wanting to go with this last sentence we were just talking about, I think there are situations where we don't want the non-custodial parent to make decisions. I mean, we will see court orders, custody arrangements, custody agreements where the non-custodial parent does not get to make certain decisions. And there's a good reason for that. Does that particular language, would that override the court orders based on that?
Mr. Chairman,
Counselor.
Representative Craigo, elsewhere in the bill, it says nothing changes the court order visitation arrangement. I have never had a situation like that. I can hypothetically think of how that could happen. Obviously, it's easy when the parental rights are extinguished or they have joint custody. The middle ground is a little more complicated. In talking with LSO in the interim, as we drafted the bill, we went off what other states had done and then started adding pieces. I don't think any state statute I've ever looked at talks about that kind of middle ground where a non-custodial parent, still a parent, parental rights have not been extinguished, but there is some kind of restriction on supervised visitation, for example, is the one that keeps coming to mind. And in all honesty.
Well, and I think Representative Craigo's question is probably pretty relevant in Wyoming. And I'm just anecdotally assuming this, and maybe Ms. Lance could give better testimony on what decrees often look like. But, line 12, it looks like the bill is attempting to address that by saying if parents share legal custody, assuming they share legal custody, the legislation is making the assumption that there aren't those restrictions. However, I would go out on a limb to say that, first of all, most decrees are stipulated to, and most custody orders are stipulated to. That's a definite fact. But that in their stipulation, I think it is very common for those decrees to say joint legal custody, and then mom or dad has physical custody, and then here's visitation. And it's almost like the joint. In my opinion, joint legal custody is so common in Wyoming, it's actually been diluted over time to where the focus in a custody battle or divorce is often, it is solely around the physical custody and visitation, and what does visitation look like. And there's usually little battle over the joint custody, legal custody portion. And so I do see Representative Craigo's point and concern is that if that's almost a standard language that appears in a decree, that even when there is restricted visitation, you may be giving more authority than you want to the non-custodial. I don't know how else to, you said, Counselor, there was somewhere in the bill that it intends to not impact other areas of law. What about, I guess my other thought is maybe a provision that speaks to a decree when it says If a parent is present to make decisions for the child, the parent's decision shall control unless otherwise in conflict with a court order or something like that. Is there, or was that already in the bill? Is there something in the bill that says if there's a decree that grants certain rights? Representative Zwanzer, you really want to jump in? Do you have the answer to my question?
I don't have the answer to your question. I have a small concern that the military department is, and their attorneys, and I'm sure they'd love to talk about family law. You're perfectly fine with this whole bill as long as you keep the 2-year provision and the 30-day notice. And the broad conversation about how this affects the state of Wyoming really doesn't have much to do with you as long as you have the 2-year and 30-day provision. And a lot of these other questions aren't really in your realm, in my opinion, whatsoever, even though it's a very skin-splitting debate, which I guess isn't it better maybe, Mr. Chairman, to have the trial lawyers or other attorneys up here to talk about the broader implications? I guess it's from the military
Suppose
department.
that's probably not a bad idea. I was operating off of the good counselor's statement of 30 years of experience in family law. So I think he has a lot of private family experience, which is why I'm enjoying the conversation. Thank you for getting me back on task.
Mr. Chairman, if I may, in response to Representative Wanter's comment, we probably deal with these power of attorneys more than anyone else in law practice because we have 2,900 military members in the Wyoming National Guard. Lots of them have these. I mean, I think I've probably done over 1,000 of these powers of attorney in my career. So obviously, we worked with the Wyoming Trial Lawyers Association to make sure that the bill satisfied what Beth thought would work for them. But I defer to anybody else's experience because it is very true. We want at least 2 years. The 30 days notice by the delegee allows us to have these things sit for a while and only spring into life, so to speak, without it causing huge complications. So those two things are our main concern. And the last thing I'll say on page 3, line 22, is where we try to get at some of these concerns because the bill says nothing here will affect any parental or legal authority otherwise limited by court order. And then going on to page 4, it doesn't affect or limit the power of any court to appoint somebody. It does. It's not evidence of abandonment, abuse, or neglect down on line 7 and 8. And then it can be revoked, which is fairly standard power of attorney language. That was our and LSO's attempt to get at some of these concerns. Whether we bore fruit, I'll leave it up to the committee's discretion.
Did you have something to add?
Yes, Mr. Chairman.
ahead,
And then just to go back to Representative Crago's concern too, I think the notice requirement is not something that we typically find in similar statutes. And to the extent that it might raise concerns on putting a non-custodial parent or a parent whose visitation rights have otherwise been limited, that might be something that the committee wants to further just consider.
Vice Chairman Washit.
Thank you, Mr. Chairman. Simply because we almost never get to see these fine folks before our committee, I would like to ask one little question before we have them step down. And before COVID, we used to have these big deployment ceremonies that I got to attend and welcome back ceremonies when the deployed personnel came back. And I'm just wondering, are we going to return to having those kinds of ceremonies that elected officials can attend and give our due regard to our personnel when they leave and when they come home? And how many folks do we have deployed today?
General.
Mr. Chairman, Vice Chairman Washit, we're currently pretty low in terms of deployments right now. With the withdrawal of Afghanistan, probably have just a handful of folks scattered out a couple of the areas, the combatant commands. We do have, coming up in June, we will deploy about 20 folks to UH-60 Black Hawk helicopters from the Army side for a 9-month deployment into the Central Command area of operations. So I will say we will probably return back to more public ceremonies as they come through. But right now, that is the only deployment that I'm tracking into that's a combatant command deployment is this one. And then probably next year, we'll deploy an additional 2 helicopters to the same location. Sir, depending on what happens in Ukraine and Russia, that certainly could change our minds on a few of those things, but that's where it sits right now.
Anything else for the military department? All right. Thank you for coming to Judiciary. All right, Ms. Lance. Suppose you've already heard all of our questions, so you kind of know the gist of where we're at and what we're trying to figure out.
Thank you, Mr. Chairman. Again, Beth Lance, Wyoming Trial Lawyers Association. Certainly, our trial lawyers understand and want to support the military and any need they may have. And so if this is something that the military needs, then we don't want to be unsupportive. However, I would ask, as you just heard, these last three speakers are looking at this only through the lens of the military. And my association is looking at this through the lens of private citizens in Wyoming and parents. And so it's important to understand that this statute does not only affect the military, but that this would then be available to all parents in Wyoming to create these powers of attorney, which temporarily delegate this parental authority for up to 6 months. There's additionally no limit in how many times that can be renewed. Potentially you could be delegating parental authority for a very long length of time. So it became the most important issue to our members was this concept that this could potentially be done in secret, and the other parent may not even be aware that this was happening. And so obviously we have parents who are divorced or maybe never married. You have a primary parent. Maybe the other parent is living far away, or maybe just not quite as active in the children's lives. But I have seen situations where then when that primary custodial parent, for whatever reason, cannot really truly care for the children. And so maybe they want their parents or someone to step in. I think it's really important that the actual other parent has notice and opportunity to be the one who steps in for their child, because it may be that if that primary parent isn't going to be there to care for them, they certainly at that point would be willing and potentially able to do so. As exists under law right now, we think of temporary guardianship law. That's what parents have operated under in the state of Wyoming prior to potentially this bill being enacted. And the important part, I think, of that is that there is a notice requirement. You actually have to have service on another legal parent in order to establish a 6-month guardianship. And the court is involved, and the court assists in vetting who the guardian to be is and ensuring that the best interests of those children is being upheld and looking into that. This certainly takes most of those things away. So this would now create an opportunity for a parent to easily draft a simple document and power of attorney and delegate that authority without the court's involvement whatsoever. But again, notice was the biggest concern for our members, was that this previously had a complete lack of notice. And so certainly appreciate the military working with the trial lawyers to come up with this amendment. And so I certainly think that amendment is quite important.
Ms. Lance, does that notice, is notice in the subsection C defined as it is in rule? So it could mean a text message, it could mean a carrier pigeon, and it could mean that I actually hire a process server and have my letter served on them.
Mr. Chairman, that's exactly right. It is not defined. Certainly our preference would be actual notice and service as is required in civil procedure. However, that the military felt that to be quite onerous. And so this was the compromise.
Vice Chairman Washit.
Thank you, Mr. Chairman. I'm glad, Ms. Lance, that you brought up this application of this statute beyond the military department, because that really wasn't in my mind as we heard testimony today. But what happens today when both parents or a single parent has to leave town for business and they're out of state for a week or two and they have minor children still at home? What happens in law for those parents to make sure those kids can go see the doctor or get picked up from school and so forth?
Ms. Lance.
Mr. Chairman, I can just tell you personally as a lawyer, I draft a document that provides essentially this. I've never had an issue. Again, as I believe was stated previously, that's essentially common law that I'm operating under. I'm not operating under a specific statute in Wyoming by doing that. But I will also say anecdotally as well, I have many friends who are not lawyers who don't draft any documents in those situations, and they've never had medical treatment denied or, anything like that. They can't report any issues, I guess I would say.
Representative Yin.
Mr. Chairman, Ms. Lance, thank you. So I think you heard from the military department saying that this neither hurts or helps them and that they can still do power of attorneys with or without this bill. Do the trial lawyers feel like we need this, or do they have any opinion on whether this bill succeeds or fails?
Ms. Lance.
Mr. Chairman, again, if this is something that the military is necessary, and maybe it isn't, again, we want to support our military members, but certainly federal law does allow specifically military members, and that's how they've been operating and how they have been executing powers of attorney in these kinds of deployment situations. There's federal laws that assist them in that. So I'm not sure either how necessary it is. As you heard today, they potentially don't necessarily need this law. And I certainly would say that this would be a big change in the family law arena for our private parents and private citizens. So certainly we'll have implications there that we've yet to see whether that's good or bad, I guess. But yes, there would be real implications and changes in family law with this bill.
Ms. Lance, I guess, so in drawing back to Vice Chairman Washit's observation, so the bill addressing military and non-military, which is in part what makes it so broad, but in your membership concerned with notice, was there any discussion to just craft this in a way that limits it specifically to military personnel, or is there a adverse effect if it is that narrow?
Mr. Chairman, I think there's just always a concern with constitutionality when we create legislation that only affects a narrow, members of the state. I think that was potentially the concern. But certainly, I think from my association's perspective, I don't think we would specifically object to a bill that only affected the military.
Representative Zornitzer.
Thanks, Mr. Chairman. I guess I'm surprised you don't see issues all over the place with this like I do. I mean, you basically can give your kids to anybody for a 6-month window and say, I've turned over my children, which, I mean, I guess if I'm being, let's say someone's being investigated for abuse and neglect, I just say, oh, power of attorney, these people are watching my kids now, you can't take them away. Or maybe you're going to, a misdemeanor prison for 6 months or jail, right? And just say, well, I mean, I can understand why you'd want to grant a power of attorney to watch your kids, but it doesn't have to go through any legal proceeding. I want to go on vacation for 4 months. it just seems like a pretty massive shift in our laws with a lot of interesting things that we have not explored this morning and doesn't sound like were explored over the last year. And so I guess my question is, do you know all those things are going to happen? And that's why trial lawyers might be okay with this.
Representative Swanser, I
But
can
do you-
use this bill to take my wife on a vacation for 4 months
And give your
and
kids.
just give my kids away to, say, Representative Grego.
And Mr. Chairman, with a power of attorney, I don't know if you even have to have his consent, right? I mean, you just write a power of attorney and you say, Representative Craigo has my kids for the next 6 months, and you say, go to his house and give this to him and
Good luck.
good luck.
And since Representative Grego is such an outstanding gentleman, I would not be committing any type of neglect, but if he were to then reject my power of attorney, would he maybe have some type of neglect issue?
I'm glad you're seeing the same concerns I'm seeing. I mean, in the family law world, right, it's a big deal with foster kids on who has training and who can legitimately oversee kids for more than 2 days. And I think there's probably a lot of good reasons to allow that. I'm just not sure a power of attorney is enough without some other type of court process. And I think those are in place you're going on well, probably not an LDS mission because you probably don't have kids, hopefully. But if you're going, I'm trying to think of extended reasons you'd be leaving the country or leaving your state for non-military reasons. It doesn't sound like a power of attorney is enough to be able to have the law in Title III say, yep, somebody else watches your kids and has power over them as long as they don't get married or you don't adopt them to somebody else. I'm concerned the trial lawyers aren't raising a little more heck on this one, then we're not sure what it does. So am I just seeing more black helicopters than exist here, Ms. Lance?
Mr. Chairman,
Ms. Lance,
Representative Zwanitzer, I would say that our membership that has looked at this sees, I think, some potential good things. And so there's just a mixed bag, I think, on it. I don't think you're wrong at all. I see a lot of red flags with this, and I think you're exactly right. I think we have certain parents that maybe have issues such as criminal issues and or drug addictions, things like that. And the idea that they would very quickly potentially sign their children to a random neighbor or something of that effect where, there's no one there to sort of watch out for what's going on there. Where you're right, otherwise the state may be intervening and the department may be intervening of family services to assist in the care of children in some situations such as that. So certainly, I think that this could be a Pandora's box. There are a lot of concerns for what we might see from this change. So I don't think you're wrong to speculate that those things may be forthcoming from this.
Representative Zwanitzer, do you have any other questions that might make you feel better about being told that you're right? Are you good?
I'm good.
All right. You made his
I
day.
do like being told I'm right, though.
He does. Further questions for Ms. Lance? Committee? No? Anything else, Ms. Lance?
No, thank you.
Okay, thank you. Mr. Winnie? How did I know you were going to testify on this bill? I just knew that.
Mr. Chairman, Bill Winnie, Sublette County. I kind of keep an eye on those military department guys, and I try to add a little bit of a naval perspective to the military. I testified on this bill over on the other side. And in a sense, you could offer that I testified on this bill on behalf, in part, not that I was requested. I have a son and daughter-in-law in the Guard and a grandchild and another one on the way. So I have that perspective too. My children.
Congratulations on that, by the way, Mr. Winnie.
Thank you, Mr. Chairman. My children are all graduated and so on. I see the value of this bill broadly as greasing the skids so that when something ends up in court, the judges can quickly resolve something, particularly with regard to a military member. In the Navy system, and I'm sure the Guard is similar, both the command and the individual are responsible for having these kind of documents in place. Now, some commands are better at dotting the i's and crossing the t's, as you might imagine, but there's still a lot of hand tooling required on occasion. Last time we crossed paths on Friday, you asked me for a submarine story. Well, I got one for you that's germane. As a young Lieutenant JG in the mid-70s, duty officer on a submarine, USS Hammerhead, scheduled to remain in port for another 3 weeks or so, and not scheduled to deploy for probably 4 or 5 months yet. I got a phone call Sunday night about 9:30 in the evening from the skipper. He said, "Get the ship ready to get underway. We're getting underway as soon as the crew gets on board." As it turned out, we had all that in place by about 2 a.m., but the powers that be said, well, we don't want it to look like something was an emergency, so we didn't get underway until 7. But literally in less than 12 hours, we were gone, out at sea for a couple of weeks. So if somebody had something in the works at the legal services offices that they expected to sign out on Tuesday or Wednesday, they'd have missed it. So those kind of things happen. Similar thing happened to me shortly after leaving command of USS Ben Franklin. There was a submarine collision in the English Channel. I was handed an airline ticket and orders, and I was on an airplane in 2.5 hours. So those things do happen. I did an investigation. I'd also note, Representative Crago asked a question about custody and custodial relations and those things. I note that I have seen some partings that were very, very acrimonious. And so those are out there. And I'll just leave it at that for now. I'd also note that when in the late 70s, when the Iran hostage crisis spun up, our submarines and aircraft carriers and supporting ships were at sea continuously for nearly a year on very short notice. And so again, those kind of things can happen. I'm sitting here myself wondering what's going on over in the Ukraine and where will that spin up to? Subject to your questions, Mr. Chairman, thank you.
Questions for Mr. Winnie? Mr. Winnie, I appreciate it, and I appreciate the submarine story. Thank you. Anyone else wishing to testify on this bill? Carol, is there anyone in the virtual world who would like to testify on this bill? Then I will close public comment on this bill. Committee, what is your pleasure? Would anyone like to move this bill? Motion to move this bill. Motion to move Senate File 13. No motion to move Senate File 13. Committee, other thoughts, questions? Just ready to get back to session? Carol, we take care of everything on the desk? All right, we are adjourned.